Welcome to the deep dive. Today, we're really digging into, well, the often complex but always interesting world of patent law in India.
Mm.
We're focusing on a specific case that went before the Delhi High Court recently. It's about, believe it or not, a plastic strapping band.
Sounds simple, but yeah, it actually raises some pretty fundamental questions about how patents get examined here.
That's right. We've got all the source materials, court filings, briefs, analysis covering this one appeal.
And our goal really is to unpack why this company's patent application got turned down initially.
Exactly. How they fought that refusal and what the High Court's final say tells us about key things like, well, how clear does your patent description need to be?
And how do examiners judge obviousness? That's a big one.
We want to cut through the jargon and give you the practical insights from this ruling.
Let's get straight into it then.
Okay, so the case revolves around patent application 7529 DELNP 2014.
Right, this was what they call a national phase application. Basically, it started as an international PCT application, claimed priority from an even earlier German filing back in 2012, and then entered the Indian system for review.
And the invention title is quite descriptive. Plastics Material Strapping Band and Method for Producing a Plastics Material Strapping Band.
The company applying, the appellant in court, is Titan, Umreifungstechnik, GmbH & Co. KG.
And they were appealing against the decision made by the Assistant Controller of Patents and Designs, the respondent.
So what exactly is this band? The application describes it as plastic strapping for wrapping things up.
Pretty standard stuff, you might think.
Well, the key is the specific recipe.
Right.
Roughly 90% polyester, about 1 to 5% polyolefin, and then 5 to 10% fiber material.
Got it. So the Assistant Controller looked at this and on July 20th, 2020, issued an order refusing the patent.
Yep, refused under Section 15 of the Patents Act, 1970, and then they gave two main reasons.
Okay, what were they?
First, lack of inventive step. That's Section 2.1. It's often the trickiest part, basically asking, is this invention genuinely non-obvious?
Would someone skilled in making strapping bands have just easily thought of this?
Exactly. The controller basically said, yes, it's obvious. The second reason was about the description itself, the complete specification.
Section 10.4, the part that says you need to clearly and fully describe your invention and how to make it work.
Right. The controller felt the application didn't meet those requirements.
So Titan disagreed, felt these grounds were wrong, and took it to the High Court of Delhi. Which brings us to this case, CA-TOMM.IPD-PT, 1114-2022.
Okay, let's tackle that second ground first, the Section 10.4 issues about definiteness and disclosure.
What's interesting here, as you pointed out from the sources, is that the final refusal order was actually a bit thin on the reasoning for this specific point.
Yeah, the detailed objections were apparently in an earlier hearing notice, not fully laid out in the final decision itself.
Which the court noted. But what were those specific objections the controller had under 10.4?
They had a few. One was the phrase, one or more articles, they felt, that was too vague. They also didn't like the use of approximate terms like approximately, up to, and about for the component percentages. They wanted more precision.
Okay.
And importantly, they pointed out there were no working examples provided to actually show the invention working, especially within those claimed percentage ranges.
Right. So how did Titan push back on these points in their appeal?
Well, on the approximately issue, they argued that using terms like about isn't just being vague, it's actually reflecting reality.
Oh, so?
They explained that measuring these percentages, often using techniques like differential scanning, calorimetry, or DSC, inherently involves what they called systemic uncertainties. You can't always nail it down to the last decimal point in practice.
That makes practical sense. You have to account for measurement tolerances.
Exactly.
Yeah.
And they stressed that those specific ranges, 1 to 5% polyolefin, 5 to 10% fiber, weren't just pulled out of thin air.
They had reasons for them.
Yes. They argued the 1-5% polyolefin was critical for getting the right link strength in the band, and the 5-10% fiber was key for achieving a balance.
A balance between what?
Between rigidity, so the band feeds properly into machines, and the ability to stretch a bit for tensile strength without snapping. Those ranges were directly linked to how the band performed.
Okay, and the one or more articles objection.
Titan basically said, look, this is just standard language in the packaging world. It refers to what the band does. It straps one item or multiple items. It's common terminology.
Seems reasonable. Did they mention other countries?
They did. They pointed out that very similar claims for the same invention had already been granted patents in places like the EU, Australia, Canada, and the US.
Always a useful point to make. If other major patent offices saw no issue, why should this one?
Right. But their biggest argument on Section 10.4 was probably about the lack of working examples. The controller wanted them, but Titan pointed straight to the Indian Patent Office's own Manual of Practice and Procedure.
Ah, the rule book. What did the manual say?
They highlighted Clause 05.03.09, and their argument was that this clause makes it clear. Working examples are only mandatory for chemical inventions.
Only for chemical, not for mechanical things like a plastic band.
That was their reading. For non-chemical inventions like this one, they argued, examples aren't strictly required by the rules.
So what is required then under Section 10.4b?
The core requirement, they argued, is disclosing the best method of performing the invention known to the applicant. They claimed they had done that in the written description.
So the absence of a physical demonstration or example shouldn't kill the application if the written instructions are good enough for someone skilled to follow.
Precisely. That was their stance. Just because there aren't examples doesn't mean the disclosure is insufficient, provided the best method is described.
Okay, a lot of detailed arguments there. How did the High Court respond to all this on Section 10.4?
The court was pretty clear. It sided with Titan on this. It called the controller's refusal on these grounds unreasoned and unsustainable.
Strong words. Why unsustainable?
Mainly because the court felt the controller hadn't actually grappled with or responded to Titan's detailed explanations in the refusal order.
Did they buy the argument about approximate values and measurement uncertainty?
Yes, they accepted that justification. They also agreed that one or more articles was acceptable industry language in this context.
And the big one, the working examples.
This was crucial. The court explicitly interpreted Clause 05.03.09 of the manual. It stated very clearly that working examples are only mandatory for chemical-related inventions.
Wow.
And it went on.
Yeah.
There is no mandatory requirement to provide examples for non-chemical-related inventions.
That's a really significant clarification from the High Court. So if you have a non-chemical invention, you don't have to provide working examples as long as your written description clearly lays out the best way to do it.
That's the takeaway. The court felt the controller kind of just rejected this point without enough thought or explanation, especially given Titan's arguments and the manual's wording.
Okay, so the Section 10.4 objections were essentially overturned by the court. But that still leaves the other major ground for refusal, lack of inventive step. The obviousness argument under Section 2.1, how did the controller build that case?
This was based on combining two prior art documents known as D1 and D2. The controller's position was that if you took what was taught in D1 and combined it with D2, Titan's invention would have been obvious to a skilled person. This is often called mosaicing.
Okay, so what were D1 and D2 about?
D1 described a method for packaging things. It involved wrapping items in a thin material, coating that material with resin, and it mentioned the possibility of adding fibrous reinforcement.
And D2.
D2 was about polyester strapping, specifically adding polyolefin to it to stop it from splitting lengthwise.
Right, so the controller saw D1's potential fiber reinforcement and D2's polyester polyolefin strap and thought, aha, put them together and you obviously get Titan strap with polyester, polyolefin, and specific fiber content.
That was the essence of the obviousness finding. But Titan fought back hard against this. They argued that combining D1 and D2 was arbitrary or forced. They said it just wasn't plausible.
Why not?
Because, they argued, D1 and D2 teach very different things and solve different problems. You can't just take substantially unrelated prior arts, mash them together, and claim the result would have been obvious.
So the argument is that a skilled person wouldn't naturally think to combine these specific teachings.
Exactly. And they went into detail distinguishing their invention. Compared to D1, they stressed D1 is about a method, not the strap itself as a product. D1 uses a thin wrapper, maybe paper, which is then coated.
Okay.
And critically, Titan argued, if D1 did use fibers, the description kind of implied a much higher amount, maybe 50-50 resin and fibers, which is totally different from their specific low 5-10% fiber content, which they said was essential. D1 didn't point towards using a small amount of fiber within the strap material itself in the way Titan did.
Makes sense. And how did they distinguish it from D2?
They pointed out that D2, while talking about polyester and polyolefin, had nothing about adding fiber material, let alone the specific 5-10% range.
Ah.
Titan kept emphasizing that this 5-10% fiber content was critical for allowing the strap to stretch under tension for strength, a benefit G2 simply didn't discuss, as it was focused on preventing splitting.
So the core argument was neither D1 nor D2 alone, nor any obvious combination of them would lead someone skilled in the art to their specific band with that crucial low fiber content and the properties it provided.
That's precisely it. That was their defense against the obviousness charge.
And did the High Court agree with them on this point too?
Yes, it did. The court stated that the controller's obviousness objection did not find favor with the court.
So it rejected the controller's reasoning?
Pretty much. The court seemed to agree that combining D1 and D2 was indeed arbitrary or forced. It accepted Titan's argument that the documents addressed different problems and were substantially unrelated.
So the mosaicing approach was flawed in this case.
That's what the court found. It accepted Titan's detailed breakdown of the differences, D1 being a method with different fiber implications, D2 lacking the key teaching on fiber content and its role in stretch strength.
And did the court comment on the controller's written order for this point, like it did for Section 10.4?
Yes, it did. The court noted that the controller's order essentially just repeated the initial obviousness objection without actually addressing or rebutting the specific arguments Titan had made to distinguish its invention from D1 and D2.
So, again, a lack of detailed reasoning in the final order.
Right. There was no real discussion in the controller's order explaining why combining D1 and D2 would supposedly be obvious, despite Titan's counterarguments.
Okay, so the court found issues with both the Section 10.4 reasoning and the Section 2.1 reasoning from the controller.
Correct, on both counts.
Which leads us to the final outcome. What was the High Court's ultimate decision?
The court allowed Titan's appeal. It formally set aside the controller's refusal order from July 2020.
But that doesn't mean the patent was automatically granted, right?
No, that's not usually how it works. The court remanded back to the controller.
Meaning it sent the application back for another look.
Exactly. The court instructed the controller to reassess the application and its detailed specification. But this time, they have to do it within 3 months. And specifically keep in mind all the observations and legal points the High Court made in this judgment.
This judgment, delivered by Justice Sanjeev Narula, sounds like it really clarifies some important points for anyone dealing with patents in India.
Oh, absolutely. It acts as a binding precedent for the Patent Office. For you, as someone potentially filing a patent, it confirms a few key things.
Like the use of approximate terms.
Yes, using words like about or approximately can be okay under Section 10.4, but crucially, you need to justify why, maybe due to measurement issues, and explain the significance of those approximate ranges.
And the working examples point is massive.
Definitely. The High Court has now explicitly stated, interpreting the official manual, that working examples are not mandatory for non-chemical inventions.
So for mechanical, electrical, software-related inventions, the focus is really on the quality of your written description of the best method.
That's what Section 10.4b requires, and the court upheld that. As long as you disclose the best method clearly, the lack of examples shouldn't be a deal breaker for non-chemical inventions.
A non-inventive step.
The message is clear. Examiners can't just pick and choose unrelated prior art documents and claim the combination is obvious without a solid justification.
The mosaicing has to be logical.
It has to be plausible. The prior art needs to be related in some way, maybe addressing similar problems, and there needs to be a clear reason why a skilled person would actually combine them to arrive at your invention. Arbitrary combinations won't fly.
And finally, it seems like a procedural reminder, too.
Yes, it really underscores the need for the Patent Office to issue well-reasoned orders that actually engage the applicant's arguments point by point, not just restate objections. It's about due process.
Right. So to sum up this whole deep dive on the Titan case, what are the main things for people to take away?
I think it really hammers home how crucial the details are in your patent specification. You need to be ready to explain everything. Why you use certain terms, why specific ranges matter technically, and precisely how your invention is different from and better than what came before, even things that look similar on the surface.
Your ability to articulate that clearly is paramount.
Absolutely. And this decision gives us clear guidance from the Delhi High Court on how Indian patent law views things like justifiable approximation in claims and the limits on combining prior art for obviousness arguments. Plus, the huge clarification on working examples for non-chemical inventions.
It gives applicants a clearer picture of the standards and how to potentially argue their case.
Right. The patent wasn't granted outright here, but Titan got that crucial second chance with very specific instructions for the examiner on how to apply the law correctly this time.
Okay, here's a final thought to chew on. The court really emphasized Section 10.4b, disclosing the best method known to the applicant, and it confirmed examples aren't mandatory outside chemistry. So, does this mean that for many inventions, the examination process should perhaps lean even more heavily on assessing the clarity and completeness of that written best method disclosure,
Right.
relying more on the inventor's explanation rather than demanding separate experimental proof?
That's a really interesting question. It certainly seems to place a significant emphasis on the quality and trustworthiness of the applicant's own disclosure for non-chemical inventions. Definitely something for you to consider when drafting or prosecuting your own applications.